it's going to be worse. It's got to be worse right now.
Just being them, and that's all we got right now. That's why I'm like trying to get it in order, and I don't want them outside hungry. Like I'm doing stuff different. Like I gotta patch the holes. I don't like, but as far as trash, when she just came in yesterday, there wasn't no trash on the floor. It probably was still like trash from the basement from when they was throwing the stuff down there. But I'm getting it up.
Sometimes I mean, I love doing my job, but sometimes I don't like what I have to do.
Mm-hmm.
There's no way that you and your kids can continue to stay there.
Okay.
Just can't, because I don't. What I've seen,
Mm-hmm.
you're not going to get it to the point that.
I know I can't though. I just need one more chance.
I don't think he can.
And from what the property manager tells me, Ms. Martin or has her children sweep all of the garbage that collects on the floor down the stairs. The video that Mia here sent me, and I viewed yesterday, has her attempting to walk down the stairs. She's literally retching to trying to walk to the basement in this unit. To say that these living conditions are deplorable, I think is a grave understatement. And the fact that there are not just Ms. Martin, but at least 3 children living in this unit, I'm not sure how anyone considers this place habitable in any way whatsoever.
Man, what do you have to say?
Me. I know that it's like the house is not in order, but I was getting it in order. And that's not feces. That was like food smeared on my children are sitting right there. It's just food smeared. And they probably did sweep it down in the basement.
But why isn't it, if they probably did that, then why isn't it being cleaned up?
Like we cleaning up. I just gotta get more cleaning supplies and stuff and get all the rest of it up.
Well, here's my problem with that, ma'am, is that we started out on June 26th.
Yeah.
With those conditions existing. You told me that you were taking care of it, and it wasn't that. We came back on July 10th, and you told me that you were taking care of it. And that,
I am.
hold on. I adjourned it to today's date for them to get the inspector in and to try to make a determination as to this unit. Now, you want me to go out there and look? I mean, I'll look at their film, but if I walk into that unit, am I going to see a unit that's habitable, ma'am?
It's like, will he explain it? Like, it's going to take a while for me to get all this stuff back.
No. I understand that. But if I walk in, am I going to see a unit that really is in a situation where people shouldn't be living in it?
Yeah, correct. Yeah.
Pardon?
Yeah.
That's what I'd see, right?
Yes. I'm being honest. Yes.
I know. And I'm just saying, when I looked at the other pictures, I don't even have to look at the other one. If you had taken steps to do it, something different, it's going to be worse. It's got to be worse right now.
Like I'm doing stuff different. Like I gotta patch the holes. I don't like, but as far as trash, when she just came in yesterday, there wasn't no trash on the floor. It probably was still like trash from the basement from when they was throwing the stuff down there. But I'm getting it up.
Wow.
Maybe if I view their video as it stands right now, tell me a reason why I shouldn't grant them a judgment in this case.
Because it's just being them, and that's all we got right now. That's why I'm like trying to get it in order. And I don't want them outside hungry.
Here's the reality. Okay.
Yeah.
Sometimes I love doing my job, but sometimes I don't like I don't like what I have to do.
Mm-hmm.
There's no way that you and your kids can continue to stay there.
Okay.
Just can't, because I don't. What I've seen,
Mm-hmm.
you're not going to get it to the point that
I know I can't though. I just need one more chance.
I don't think you can.
Okay.
Part of the reason I gave that adjournment and asked you to do something before was to see if you could. I'm not going to sit up there and just say somebody can't do something,
Right.
but you haven't been able to. And so then my question is, if I give them a judgment today, you got to be out in 10 days. Now I realize how many kids you have.
I have 4 right here. Then I have a daughter, but she stays with her dad.
How long is it going to take? How much time do you need to get you and your kids?
I don't know because I'm like,
Pardon?
I don't know. I don't have anybody. Like, it's just us. Yeah, I'm
Pardon?
unemployed right now. So
I'm sorry?
I said it's just us and I'm unemployed right now. So I really, I don't know.
Right. There really isn't. And you kind of admitted it. I mean, there isn't anything for this court to try at this point in time. So I'm going to find that there's no tribal issue in this case. I'm going to issue a judgment for possession. There's not a redemption amount. Ma'am, I'll extend out the period in time a bit, but your redemption date you need to be out. I'm going to give you to August 7th to get yourself and your kids out.
Okay.
All right. Try to figure out some alternative living arrangements. You understand that?
That's fine.
So I'd suggest that you start working on that now. I mean, I hate doing this, but I think the circumstances dictate that it can't happen any other way.
Okay. That's fine.
Right?
Thank you.
Pardon?
False judgment.
Hearing on behalf of Group 5.
Present, Your Honor.
All right. Where are we on this case? What does plaintiff have owing?
The amount owing is still $1,492, including court costs. I think the last time we were here, she had indicated she was going to make a payment and or apply for assistance. We've received no notification that she has applied for assistance, and we've received no payment. So we're asking for a judgment.
So you haven't received the payment, but she paid $300 to the court.
Oh. Okay.
And she did file the rental assistance form. Have you heard back from any of the folks?
Your Honor, I did speak with DHS today. They said that it would have to go through the case manager, which is going to look over the SCR to finalize it. The case worker had stated they don't think they'll be able to help me, and they should get me a letter sent out saying
You don't have a decision on that as of yet.
I don't have a letter decision, a final decision, no.
Your Honor, I would request, of course, that the $300 be sent to my client and that a judgment entered for the balance with the writ to issue in 10 days. It appears that she's not going to be getting any help. And her portion of the rent at the beginning of August will be $605. And she hasn't made a voluntary payment since April, other than the $300.
That information is incorrect. The 603 is not in effect until September 1st. I was planning on making another payment in 2
What-
weeks,
What is your rent for August, your portion?
$295.
I have 305. Oh, for August?
For August.
Do you know what it is, Cosetta?
I'm sorry, it's 305.
It's 305 for August.
All right, for August. All right, so Ms. Kelly, you said you were going to make another payment?
Yes.
Okay, when were you planning on doing that?
The date would be, today is the 24th. That would be in 2 weeks when I get paid bi-weekly.
I got you. Okay, so on the 7th,
Yes.
what do you think you can pay?
I can pay 500 or more. I just don't want to say I can pay more than 500, but I know the minimum I can pay is 500.
And then her August rent kicks in. So we're just kicking the can down the road, Your Honor.
With a denial letter from the SCR, once that's finalized, and if they do deny me, I can send that information over to Salvation Army and see if they can assist them with the payments.
But here's the thing. At some point, even once you get to the 603, you're working so you can maintain your unit, right? So really what we're talking about is this back balance.
Correct.
And I've got 300. If she gets 500 on that date, so then of this balance that you have here, she's got about a third of it paid
But
in
then
the court escrow.
then the $305 for August kicks in too, if you're going to push it down.
No, I know, but I'm saying I'm just going to round down numbers. If she pays the 500, right? This is how I get there. If she pays the 500, I take 300 of that 500 and say that's really her August portion of the rent. That means I have an additional 200, which added to this 300 is 500, which is about 1/3 of the 1,500 that you say she owes.
Correct.
I know.
You're right for a change.
Wow, for a change? Okay. All right. Did you hear that? All right. So my question becomes, and if she's working, at what point can she get all this amount paid off?
The second week of August.
You can get everything paid by then, you think? Or what do you mean the second week of August? What happens then?
I get paid again. I get paid bi-weekly.
All right. So did you get a check today or you get it tomorrow or next week?
Well, I already paid the 300 from that check. Yes.
Got it. So your next check, that's why you say the 7th, because that's
Correct.
the week of your next check, right?
Correct.
And then the 21st, but you say on the 7th, you can give 500, but then you don't have any monies till the 21st of August.
Correct. I'm still waiting from something from Treasury, but I don't want to say that I'm going to get that. They said it's still processing and that takes 7 to 14 business days, but I do not want to say that I'm going to take that 700 from there when it's not finalized.
No,
and
I got you. I got you. So here's what I'm going to do. I'm not going to grant a judgment at this time. She doesn't have a full answer from SER, so I'm going to give additional time. So I'm going to adjourn it to August 14, 2026 at 3 p.m. I'm going to indicate the defendant is to pay the $500 directly to the landlord. Okay?
To the landlord, not the court.
Yes.
Okay.
Pay it directly to the landlord.
Okay.
All right. That way they'll have the 500 And that, however they want to do their accounting, they're obviously going to apply it to the back balance, but that's okay. At least it's the best ways the bleeding is stopped. And then you've got some payment toward that back balance. And I've got the 300 here. And then I'll release the $300 in escrow to the plaintiff. Then we'll see where we are. I would then encourage the parties, since she'll be at that $1,000 range or thereabouts, once all of that happens, to work out some payment plan to maintain our housing. But if you don't want to do that, then I'll do it.
Ms. Kelly, that payment has to be in a cashier's check.
Okay.
We can't take cash or a regular check, so it has to be made out to Randolph Court.
All right, that's fine. If that's what I don't know why landlords make things so difficult. I understand the protection on that. Ms. Kelly, pay the $500. Pay the $500 to the court.
Okay.
Okay, that way you don't have to pay a cashier's check fee and all of that stuff. You pay it to us, and we'll write out a check.
Okay.
All right,
Perfect.
that's just going to hold up that payment, but that's fine.
Okay.
All right, pay
No.
the 500 here, and then we'll release $300 to the plaintiff, and then some point once the 500 gets in, we'll release it. But I can't write it now.
Okay.
Then we'll see everybody on the 14th. Thank you.
Okay.
Thank you, Your Honor.
Clarify the situation, Your Honor. It's late on Friday. I'm a little slow. We're coming back on the 14th, at which point in time she'll have 500 plus the 300 paid in. And then, of course, we will have to add in the 305 for our August rent.
You'd have to add in the 305 for August rent, but I'll have $800 of hers. She's looking to that next week to be able to then clear the balance. So if you guys don't want to give her the time to do it, I'm going to find a way to give her the time to do it.
I'm not surprised.
Shouldn't be.
I know.
Thank you.
Thank you, Your Honor. So
Thank you, Your Honor.
the 14th at 3 p.m.
Yes, sir.
Fine. Thank you. Have a nice weekend.
Have a great weekend. Thank you.
Ahin LLC versus Connie Clark. And David Clark.
Good afternoon, Judge. Ashley Atisha, P82009 on behalf of plaintiff.
Oh, there the Clarks are. Hello.
You have to unmute yourself.
Yes, I'm present, sir.
All right. I think there's David.
present.
There he is. Okay. I have 20,185.20 owing, including court costs.
That's correct. And we've reached a consent judgment with
Okay.
a pay or vacate date by August 15th.
Okay. So they need to pay that full amount by
Yes.
August 15th?
Or vacate, yes.
Sir,
And-
may I ask a question here?
Yes, you may.
Okay, thank you. We were working with their attorney. We had had something simple to agree. At this point, she texted us a lot of details this morning that she wanted us to sign. And then also she said she would sign it for us. And at this point, we would like to seek advice from our own attorney and have time to, find an attorney and speak with them.
Okay. So you don't want to, you may have reached an agreement, but you want to go to your attorney to take a look at whatever it is.
Absolutely. We had asked for August 31st to be able to move, and that was denied. But at this point, with all the details that are new presented to us, we feel that we need the advice of an attorney for us ourselves. As well as we have not heard back from HAWC nor SER at this point for some rental assistance.
Judge, may I briefly respond?
Yeah. Go ahead.
I don't believe that I don't know if they filed proof that they filed for rental aid. I haven't received such. And with regards to the details that she brought up, I informed them that this was a money judgment case, that if the amount was paid, that we'd set aside the money judgment. And also I informed them of MCR, it was 4.201J, explaining that if they wish to set aside the judgment because they're not represented by an attorney, they would have 3 days to do so. Those are the new details that she's discussing. Otherwise, I've sent a copy of the judgment via text for them to review, and nothing has changed from that.
And we did not receive that. I looked for it in my email and I keep looking for it. I have not received that yet.
It's in your text messages.
You asked for my email address and I was looking in my email.
All right, this is maybe what happens when I let everybody appear by Zoom and nobody's here in the courtroom that I can. All right, so here's what I'm going to do. Try to be nice, but I'm going to adjourn this to August 14, 2026. There may be additional rent certainly that kicks in at that point, and I'm well aware of that. That's at what time? At 3 p.m. That's my next available time to do it. And I'm going to order that both the parties, but all parties need to appear in person on that day. If you get an attorney, folks, you also need to have that attorney here on that day.
Yes, sir.
Thank you.
Thanks.
Thank you.
Thank you.
Peninsula Place versus Afra Pinjari.
Good afternoon, Rebecca, the plaintiff.
Your name?
Afra Pinjari.
All right, where are we on this case?
So I went to go to DHS yesterday. She said that I need a summon from the court saying
You went to DHS. They said you need paperwork from the court and they won't let you file until you have it.
they said they'll let me keep my application, but they cannot make a decision because they can't help for non-payment. They only help for eviction. And I started that's what she told me. That if I get something from the court saying that
You're being evicted, then that's fine, which means they're asking for a judgment. They can't ask for a judgment. They're supposed to help you prior to asking for a judgment. Do you have the name of the person that you spoke to?
I don't remember her name. She was a supervisor though.
Probably not.
That's what they
No, yeah, that's what they call them. Sometimes anybody can get a title.
But she said until I get that, I can't do anything. But
Yes, you can.
tomorrow,
Okay, no, I hear what you're telling me. Okay, and I'm not angry with you. It's how much is owing?
Your with costs, Your Honor, $1,712.87.
All right. How much is your monthly rent?
when I signed my lease, it was $629.
$629. Does that sound about right, folks?
Ish, Your Honor, I think it's a little like 630 something, but close.
Yeah, but close. All right. So let me ask you this. Do you have any funds to pay anything to the landlord at this?
So tomorrow I was gonna take in a $400 cashier's check.
400?
Yeah, and then I started a new job on Monday. And so I've been door dashing and stuff too. So I'll be able to get them all the money by August 31st with August's rent.
Right, but what can you pay? You're gonna pay 400 tomorrow. Then let's say the first half of August, how much can you give them?
The first half of August, I could give them probably give them 1,000.
1,000?
And not 2 weeks from today, I could probably give them 1,000.
2 weeks from today. Well, you say probably
No, I'm gonna give them 1,000.
1,000 by the 7th?
Yeah.
All right. So there's gonna be a total of 1,400 coming in.
Mm-hmm.
Okay, and we're gonna have to tack 6 on there, so we're at least making some progress. So here's what I'm gonna do, Council. I'm gonna adjourn this out to my next available date of August 4th, 2026 at 3 p.m. You need to make those payments.
Mm-hmm.
Where's Ann? And if you're listening to me, can you write down this name so I can call the individual at DHS? So I can put this case number down because I want to talk to the people at DHS about that because that's incorrect information she's given. All right. Okay. See everybody then, get that paid, and then we'll be able to deal with it.
Thank you.
Thank you. Peninsula Place versus Shemaya PO. So I got it wrong. So what is that?
I'm Dominican, so it's like Haitian.
Okay.
Yeah.
But right, but I mean I wanted to do French and I wanted to do Spanish and I'm gonna mess it up like I did the last time. All right. All right, where are we on her case?
So basically they the $10,000 thing, my bank is like investigating me for like scamming and fraud. So they haven't like cleared I have the $3,000 that I owe, but since it outdid to the 10,000, they're trying to not get me for scamming, but they need me to verify. So I talked to somebody with them earlier. Her name's Ashley. She said basically I have 10 days. And I was like, okay.
Ashley said what?
Whatever office that she is a part of, because I called
that she being who,
or the
pointing at
person
Holly?
who owns the person, not Holly, the person who's getting represented by who's representing Penn Place.
Yeah.
Yeah. I called the office place, the attorney office, and I told her exactly what I'm saying to you. And she was like,
you'll have 10 days to get it paid.
Yes.
Oh. I didn't know they had a judge in their office.
No, not the.
Okay, no, I'm just saying that.
No, I was trying to be proactive before the court.
Oh, I know.
Okay.
Probably in pricing you of what could happen.
Okay.
All right. So the 10 isn't gonna, you don't know when that's gonna clear.
So I didn't have the 10,000 clearly. I had exactly what I owed them, but because I pressed submit so many times, it came out to $10,000. So yes. So because I did that, they said they were going to return my original 3,500 that I owed. But because I did the 10,000, they're saying I'm scamming.
Who says that?
My bank, Huntington.
Okay.
So I have like
who's returning the money?
So Huntington is going to return. It was only 3,600 in there. It was only 3,600, but it overdraft. It was ACH. It overdrafted it to 10,000. So they're gonna return me my 3,000.
What?
MIP show.
And you said the origin of that is what?
Dominican, Haitian.
Dominican. Okay. Is that how they do this down here?
No.
Okay.
I'm just saying. I think I'm scamming them because I did an ACH of $10,000. So I'm just waiting for my original 3,600 to be put in my account. But if that doesn't happen sooner than later, I am able to make other constitutions, make other plans.
Okay, young lady. When can you get this paid?
I hope
without having to hit any buttons.
I was gonna hopefully I was hoping that by next week put the funds back in my account.
When this paid?
I could get it paid on the 31st. I could get it paid on the 31st.
Are you sure?
Yes, that would if they don't put it in my account, I could get it from somewhere else.
I don't know what that is. I don't want to know. Okay, so by the 31st,
yes.
Hey.
Yes.
All right. What I'm gonna do. And how much is your monthly rent?
$860.
So how are you gonna get that paid?
Oh, for next month. Oh, I have a job. Oh, I have like money. I have a job. I'm good for my new balance. I just need to pay this previous balance. Yes. I'm good for the.
So when are you gonna have August?
So I'll have August. I don't have that on the 3rd. It's only $860. I get paid. I'm just I'm just saying, this 3,000 that they took put me in a hole. I owe 3,000 to them.
Oh,
I'm gonna have
I
August.
don't know what to do. I really don't.
I will have August's rent.
Okay.
Yes.
And then you'll be able to keep that up. But by the
Yes.
31st, you can get all of this clear.
Yes.
I don't know what it is.
I can. I was trying to get the funds back to me without having to reach into my family and stuff because I don't want to hear their mouths, but if I have to do that.
Wow. Wow. I don't want to hear the mouth. Me. All right. Here's what I'm going to do. And this might be an unwise call on my part, but I'm for this young lady.
Thank you.
Just because of the way she said it, couldn't be scamming a bank because that's not the way you do it.
No.
But that's okay. I don't want to tell you how to do it.
Yeah.
I'm going to adjourn this out to August 14, 2026 at 3 p.m. I'm going to put down in here that you'll pay that $3,600 by July 31st. So I will be angry if it's not paid.
Understood.
You got to talk to your family.
Understood.
Okay. And since I'm going out to that date, your August rent will click in. Right? So you got to have that paid. But if you're going to pay that by the 3rd, get this 36. It's 36.94, counsel. Is that right?
Well, Your Honor, it was, and then she had NSF fees because she
Yeah.
Okay.
All right. So what's your current balance because of NSF? Because she clicked the button.
$35 for each one, and there were 4 payments and 4 reversals, and I understand she's waiting for them.
Wow.
I was clicking like I was like, I was.
So what do you have? How much is owed?
I have 3804.17 because it looks like another late fee came in, another $30. Hope my math.
Okay, so 3804.17.
Is everything with the cost, right?
That's with the cost.
It's with the cost.
3804.17. So can you get that paid by the 31st?
I will be going to my parents with my head down. Yes, I will. I can get that paid. I can.
I'd love to hear that come. No, I don't.
No, you don't.
All right. You pay the 3804 by July 31st, and then get your August rent paid on time. I'm going to adjourn it out to the 14th. If everything is paid and your account is 0, I do not need to see you on the 14th.
Okay.
Let me repeat that. If everything's paid, do not come back in here.
Okay.
All right. Okay.
Thank you.
You're welcome, young lady. Have a good weekend. Is that it for you, counsel?
It is, Your Honor. Have a great weekend.
You too. And hello, Holly. How are you?
I'm well. Thank you very much, Your Honor. Have a wonderful weekend.
You too.
Thanks.
Ridgewood, Ypsilanti versus Anthony James.
Good afternoon, Your Honor. Mark Schlesinger appearing on behalf of plaintiff.
Your name?
Anthony James.
All right. And how much is owing on his account?
Judge, as we sit here today with cost $906.81.
All right. So about where we were. How are we going to get that paid?
I need some time at least, man. I work. I got a job. I had to miss work today for this. And they mad at me about this.
Okay. So how much time?
30 days.
To get this all paid?
Yes, I will.
What about August rent?
Huh?
What about August?
I'm moving out of the apartment I'm at this right now as we speak.
When are you moving out?
I'm moving out as we speak. I should be going out of there by the end of the month because I don't want to live there no more.
Okay, so here's what I'm going to do.
Mm-hmm.
How much time do you need to move out? Oh, there's a money judgment you requested, right?
That's correct, Judge.
All right.
Yeah.
So here's what I'm going to do. I'm going to adjourn it to August 14, 2026 at 3 p.m. Defendant says he's moving out. Here's what I'm going to suggest to you in the interim, sir, is that you move out of the premises, this back balance, if you move out before the end of the month, that's where it's gonna stop, I think. Go into the office or call the attorney's office and try to work out a payment plan to pay this back balance.
Okay.
But it's important, you gotta be out of the unit. Okay?
Okay.
Thank you. Right. Okay. I don't know what has happened. But it's okay. I'm good. Bridgewater, it's Lanny versus Sarah Lee.
And good afternoon again, Your Honor. Mark Spessinger appearing on behalf of plaintiff.
Hello.
Hi.
What's your name?
Sarah Lee.
All right. And how much is owing on this?
Judge, this is with court costs $3,494.71.
All right. How are you intending on getting this paid?
Like I said in the last court hearing, I applied for SER and I filled out the form to prove that I did.
Still haven't gotten an answer?
So I have to reschedule an appointment for them because they need more documents. I've already submitted several, but I think they just need more information. And then I am planning to pay by the first week of August. And since that means that the August rent would come in, I would also pay for that.
Okay.
Yes.
So that I understand what you're telling me. Right. Somewhere in the week that ends in the 7th,
Yes.
you're going to get this back balance plus August rent paid.
Yes.
I'm going to give her an opportunity to do that, counsel. How much is your monthly rent?
About $1,450 or $1,500, depending on my water bill.
Got it.
I would be happy to get that money in August as well, Judge, so I'm agreeable.
Okay. So
Not
what
that,
I'll do.
not that my agreement makes any decision and it makes any sway in your decision making, Judge.
Yeah, well, it can help sometimes. I'm going to turn this out to August 14, 2026 at 3 p.m. Now, if you say you won't have anything until the 7th, but just so that you know, if everything was paid by next week, this case would be dismissed.
Yes.
Okay. But if you pay everything by the 7th plus August, same result. It's going to be dismissed.
Understood.
Okay. Thank you. Have a great weekend.
Thanks so much, Judge. Have a great weekend.
You too, sir.
Thank you, Your Honor.
Because my day doesn't get any better. What'd you say? Don't call me. What'd you say? Okay. Go ahead, just call the case. My label. Really? They just didn't put a label on? It was just funny. Demellaroo Holdings versus Petberg.
Good afternoon, Your Honor. Julia Moran of Varnum LLP on behalf of plaintiff Tamala Rue Holdings LLC.
Good afternoon, Your Honor. Ellie Kirsten on behalf of defendant.
All right. And where are we on this case?
Your Honor, the last time that we were before you on this matter, the court had some concerns about jurisdiction. We have filed a bench memo detailing the jurisdictional basis for this matter. We are not sure if the court has had an opportunity to review that at this point.
Oh, I did, and I read it.
Then, Your Honor, our position is fairly clear that under MCL 600.5704, the court has a general grant of jurisdiction over summary proceedings to recover possession. And that is exactly what we are seeking here under two distinct subsections of section 5714.
Right, but under that notion, you're seeking this as a non-payment of rent as opposed to a termination, correct?
Your Honor, this is an action where we have multiple bases for seeking possession. The first theory was under a non-payment of rent theory, as there is still outstanding balances that, as defined by the lease, are rent and have not yet been paid. But separate and independent of that, through subsection CI, after termination of a lease, pursuant to a power to terminate provided in the lease or implied by law, the court is also empowered to grant possession. And in this case, there have been numerous independent events of default. We have opted to terminate the lease and provided notice of that, despite the lease itself stating that no notice was required. There has been notice. At this point, the defendant is still occupying the premises. The lease has been terminated, and we request that the court grant us possession in light of that.
Go ahead, your turn.
Your Honor, it's defendant's position that the court lacks jurisdiction to hear this summary proceedings matter. As to the first point about jurisdiction for non-payment of rent, the amount stated in the notice to quit was paid by the defendant, the $16,000 and change. I have the exact amount if the court needs it. So that amount.
There was presumably a late fee that kicked in. I'll let you finish your points, but one thing I was trying to figure out, that payment of the 16,000, I think 400 something, whatever it was that paid prior to the filing or institution of this action, or was that paid after it?
Your Honor, I could answer that question. There was an original letter sent that there was an outstanding sum of $32,000. Half of that was remitted. The other half was not. This action was initiated, and since then, $16,000 has been remitted. However, there is still an outstanding balance that is attached to a late payment from June. And I would direct the court to the lease itself, which states that.
You're not answering my question, because the answer to my question doesn't take that long. At the time of the filing of the complaint, had the $16,000 been paid?
No, Your Honor.
Okay.
Your Honor, if I could clarify, so as plaintiff stated, $32,000 was originally owing. $16,000 was paid on June 16th. The notice to quit was issued, indicating that the second half of the payment was made and that it was due in 7 days. And that second half was paid by the date listed on the notice to quit.
So, okay. So both of those cannot be true. Because you couldn't have filed a complaint for non-payment prior to the expiration of the notice.
Your Honor, from my understanding, the notice to quit was dated June 16th and the complaint was filed that same day.
Is that right? Counsel?
Your Honor, I am. Yes, Your Honor, both of those were filed on the same date. The issue with the non-payment of rent here is that that was an event of default under the lease. That notice was provided in an abundance of caution to dot our I's and cross our T's, but the non-payment at issue independently created a basis to terminate the lease, which was exercised.
Whoa. No. Did you read the notice that you gave them?
Yes, Your Honor.
And what's it say about the payment of the amount?
Your Honor, this notice, the non-payment of rent subsection is separate and distinct. If the court does not agree that this non-payment of rent provision, statutory provision, allows us possession, we would ask that the court then instead consider this under subsection C1.
Did you give them a 30-day?
Your Honor, the lease did not require a 30 days notice to terminate the lease.
You have to invoke the jurisdiction of this court.
Your Honor, we provided them numerous.
I'm statutory. You can't just bring things to me. On summary proceedings actions, whether commercial you have to invoke the jurisdiction of the court.
Your Honor, we believe we properly have. We've provided them numerous notices and attempts to cure. They have not. And this assertion that they now believe the court lacks subject matter jurisdiction is inconsistent with their answer to the
I'm
complaint.
inclined, counsel, to agree with them. Because you took a non-payment of notice or a non-payment notice, effectively said you have 7 days to cure. They cure within that 7 days, but you file a complaint prior to the expiration of that notice. That does not invoke the jurisdiction of this court at all. So under that theory, yeah, I don't think you can proceed. Quite frankly, I can't proceed.
Your Honor, the non-payment was one of two events of default that we invoked in our complaint.
You keep saying that to me over and over again. Really, I'm not that old. I hear you. I heard you the first 2 times you've been telling me that. The problem is that then you try to invoke the court's jurisdiction without a notice at all. And I'm not sure how statutorily you can do that. And quite frankly, your memo doesn't help me.
If I may, Your Honor.
Yeah, go ahead.
We believe that we have properly terminated this lease. We believe that we've brought a summary proceeding for possession following a proper termination. Not only was there lack of payment, there are issues with other provisions of the lease, including inventory, supply obligations that were not met. 30 days notice was provided. They did not cure those deficiencies. We believe that there are multiple independent bases for these summary.
The 30-day notice was provided?
Your Honor, we sent them.
Did you file the complaint prior to the expiration of that 30 days? Like you did with the 7-day?
Your Honor, we provided the notice of material breaches on May 18th, and we filed the complaint on June 16th. And as of today, those remain uncured.
Your Honor, if I may, maybe provide some clarity. So she is correct that there was a letter issued on May 18th to defendant regarding what plaintiff believes were material breaches to the lease. As I believe was discussed at a hearing last week, we dispute that the material breaches. Nevertheless, there was a letter issued on June 16th that included the 7-day notice to quit and also indicated plaintiff's position that the lease was terminated as of April 23rd. It's my understanding that there was no formal 30-day notice. However, even if there was, it's defendant's position that this court lacks jurisdiction to hear these summary proceedings because plaintiff has continued to accept rent for June and July, which would further restrict the jurisdiction of this court.
Your Honor, the lease is clear that when an event of default has occurred, even if a later payment is made, it does not change the fact that an event of default has occurred, which entitles termination of the lease. If the court would like us to submit more fulsome briefing on the jurisdiction issue or amend our complaint to parse out those individual events of default that make the summary proceedings proper, we would respectfully request that the court grant us an opportunity to amend and do so.
Respectfully, Your Honor, if I just may respond to that point. The lease, she is correct that there is language in the lease. However, leases routinely, landlords routinely draft leases to include unenforceable provisions. The law is clear, as this court indicated earlier under Park Forest, that once landlord accepts rent for future months, that they waive their notice to terminate. And that is what has happened here. They have given the notice, they have indicated that the lease is terminated, but continued to accept rent as this case has proceeded.
And Your Honor, we have cited authority in our bench memorandum that we provided to the court a couple of days ago, stating that acceptance of rent does not foreclose the ability to proceed with a summary proceeding.
But can create a park forest issue.
And Your Honor, again, we would request then that we have the ability to amend our complaint and we can parse out each of these amounts of default, the proper termination of the lease, and the amounts that are currently outstanding, if that would help clarify the issues for the court and show why the court has proper
It's actually
jurisdiction.
very clear. I think the court is very clear. In terms of what I should do, it only becomes an issue of whether or not I give you an opportunity to provide more briefing to the court. But folks, also, as I understand, at this very moment, there's only $1,021 in dispute.
That's my understanding, yes.
Yes, Your Honor, there's $1,021.23 that comes from a June late payment.
All right. Here's what I'm going to do. I'm going to make a ruling and then guess I'm going to allow the other part. This court is going to specifically rule that as to the non-payment rent issue, for other reasons, but specifically for the reason that the complaint was filed prior to the expiration of the notice. Also, since the non-payment of rent is remediary, sure, the plaintiff or the defendant remediated by the payment, which this court believes would divest it of any jurisdiction, even if jurisdiction attached. I don't believe regarding the non-payment that jurisdiction ever attached because the complaint was filed prior to the expiration of the notice to quit. And therefore, and then also was paid prior to, well, not prior to the filing of the complaint, but would have been had the complaint been filed properly. Best way to put that. And so this court doesn't believe that it lacks subject matter jurisdiction over the case and that the subject matter jurisdiction hasn't properly been invoked in this court by the plaintiff. To the extent that even one were to believe that the court were wrong in that, this matter then upon it immediately being filed with the court, the defendant having been paid, the remedy should have been as to that issue dismissal. So whether it needs to be dismissed, whether it's with reference to the subject matter jurisdiction or just the factual basis of the case, would require its dismissal as to the non-payment of rent. As to the issue of the 30-day, this court, I will say, is leaning toward the issue that there was not proper notice as to that 30-day. And then to the extent that there was even that the notice was proper, the notice that was given, that we have a park forest issue as it regards this case. Now, sometimes agreeable that park forest may or may not be applicable to certain types of commercial circumstances as opposed to residential. Certainly the court will take a look at that. So what I'm going to do is then I'm going to adjourn to August 14th, 2026 at 3 p.m. I will allow each side to file a brief to the court, looking both at the jurisdictional issues regarding the 30-day as well as the park forest issue. I would like those, if you could, that if I could receive them at least by the Monday prior to the, what date that is, the Monday of that week of the 14th. I would appreciate it. Give me a chance to read it. Any questions?
No questions from plaintiff.
Thank you, folks.
Thank you.
Take that. Well, I'm glad you got those muscles to carry it. Court calls the case. North Point Bank versus Maurice Warner.
Ready, Your Honor. That's a tough act to follow.
Yes, it is.
May it please the court, my name is Eric Nasland, and I appear on behalf of the plaintiff. My P number's 42648, and we're simply seeking, I believe, an unopposed order to extend the time to execute on the order of eviction. Some of the details were included in the motion.
Yes, I saw that.
So all
And I don't have opposition to that motion granted.
thank you, Your Honor. Have a great weekend and
Same.
enjoy your.
Called you before I called that one.
Appreciate it.
All right, take care. Maple Heights Apartments versus Tate Chatfield.
Good afternoon, Your Honor. Alex Holzman on behalf of the plaintiff.
Tate Chatfield. They are not here. If you'd like to raise your right hand to be sworn, take it to vote. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth to help you God?
Yeah.
What's your
This
claim?
is a non-payment rent action. My understanding is from the last hearing that the tenant did appear and indicated that he had vacated and was living in, I believe, North Carolina. The property had an opportunity to post notice and inspect the unit. We do not have keys. There's still several items of property in the unit. There is a note that's unsigned that says they intend not to return. However, given the circumstances and the outstanding rent and the lack of direct communication and keys from the tenant, we'd move for a default judgment at this time. The rent to retain possession of $2,090, cost of $170.09, for a total outstanding balance of $2,260.09. To my knowledge, the residence has been kept in reasonable order that works intended use. And to my knowledge, the defendant is not in the military, incompetent, or under VA.
Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with a writ to issue 10 days.
Right, this is the judgment.
Yes. Court does call the case. People versus Jeffrey Patrick versus Stephen Kisani.
Thank you.
Your Honor.
Hello, your name?
Jeffrey Patton.
And Steve Kisani, not checked in. Like take a default. Raise
Your Honor.
and do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, Your Honor.
All right. How much is owing in background?
The amount owed is $1,250, which includes rent and late fees. And 7-day notice was served on June 19th.
I see that.
And yep. I'd like to take the default judgment of possession.
Judgment to the plaintiff, that is by default for possession. Redemption amount is the $1,250 plus $90.81 costs with a writ to issue in 10 days. Sir, I'll need you to prepare a judgment for the court signature.
You I grabbed that over.
Not at the front counter.
Thank you, Your Honor.
Here. Court calls case Thomas Tiplady versus Louis Cologne. Your name?
Thomas Tiplady.
All right. All right, where are we on this, gentlemen?
Did you get a copy from the front of the 508 that I created? Oh, sorry. We've also had some discussions since the last court date, both here in the parking lot and a couple of phone calls and a in-person in the last few days that, we're far apart. but we're trying to stay polite.
My turn.
Go ahead.
Yeah, I'm having a hard time understanding this exactly. I've known Louis a long time. A few years ago, his mother died and he inherited a house in Florida. He has that house, and just recently he had some money problems trying to line him up with the Social Security check with the date of the payment. And he was late a couple times. That's never been an issue with me. I covered him when he lost his business and took months, and that was fine. I'm good with all that stuff. But now he just got an inheritance and gave me a picture of the check, $337,000, $337,000 something 15 cents.
You guys are not in agreement on this at all.
Well, why is he doing it?
I don't know, but are you not in agreement?
No, I want him to leave. I'm kind of in a problem as a time pressured, and I want to get him out, and I want to get the house fixed up so I can have my granddaughter move in so she can help me out with my wife. And I want to have my stepdaughter take over the financials of it, because I spend 3 hours a day looking for my phone. And so, I mean,
That non-jury trial in this matter for August 25th, 2026, 9 a.m., all in person. Make sure to bring all of your witnesses, all of your exhibits, and then I'll hear testimony at that point in time. Thank you.
August 25th, 9 a.m.
Yep.
Thank you.
I'll get that out there.
Yes, sir.
May I ask one question? Is it possible? Louis just informed me he hired a lawyer now, and this is the first thing that the lawyer did. And is it possible for a lawyer to continue to submit things to you, contents or motions or whatever, and postpone this? Because Louis says he's happy to leave in November, but he's not going to leave until November. Possible?
I don't know, sir. It's possible for me to answer that question.
You understand what I'm asking?
I do understand you.
Okay.
It's possible for me to answer.
Fair enough.
Thank you.
Thank you.
It's a circle.
Sir. I'm sorry. Oh.
Legends of Wood Village versus Leina Awad.
Hi, good afternoon, Judge. Mark Wasbury for plaintiff.
And Tiffany Coleman. Oh, leave Tiffany out. She got mad last. Names.
Tiffany Coleman. Lena, what?
All right, where are we on this case?
Judge, they did make a $500 payment this week. The current rent to retain possession is $1,837.83. That does not include the court costs. The court costs are $192.50 for a total of $2,030.33.
All right. Where are you guys on this?
Well, like I said before, we're waiting on the income verification for the rental assistance. So that's still in process. And then I've still been Amazoning and everything, which is how I got the 500. And then, like I said before, I won't really be fine until like mid-August because I have like contract work and stuff coming in. So until then, I'm paying like little by little, clear the balance.
How much is your monthly rent?
$1,869. I know.
When you say you're paying little by little, and I'm not addressing you, Ms. Awad, because I realize, well, this is a joint and several lease.
Yeah.
Your portion you had paid, right? So whatever half of 1869 is,
Well, I pay $100 more. So I pay $984. She pays $884.
pay now.
We don't do half.
All right, I don't. Okay, whatever. But half of that amount. When would that be paid? Well, no, the full amount. How would you come up with that if I don't give them a judgment to?
So I have like contract work, like I said, I have something for $1,000 on the 16th, then I have $1,500 coming in by the 16th, have that I'm doing on the 6th for 300. So like I said, it's like all coming in within the first 2 weeks of August, as well as still Amazoning. So that's why I was saying before when we came here that I really wouldn't be able to catch up on all my bills until mid-August.
The portion you, Ms. Awad, pay, you're going to pay that timely for August,
Yeah.
right? Which you have been before. All right. Have you ever been before the court on non-payment of rent?
Right now?
No. Have you ever had another case?
Like when I was younger, my younger 20s, yeah.
No, sure. Yeah. Yeah, way back when I was in kindergarten. Is that?
Mine's in younger 20s, but I've never been like evicted or anything.
Oh, okay.
Yeah, no.
But with this landlord, you've been paying timely, right?
Up until, yeah, this is our second lease. So yeah, up until like 2 months ago.
You had a lease before this, they renewed it.
Yeah.
And then, okay, that's what I wanted.
Started facing some financial issues and got behind. So
I get it.
Here we are. But yeah, this is our second lease with them.
So what I'm going to do is I'm going to give them a shot. I'm going to adjourn this out to August 14th, 2026 at 3 p.m.
Would you mind?
Oh boy.
I'm sorry.
I decided up to 2. I like a wide press.
Would you mind doing it till like, I heard you saying like the 21st, because I think I could have it all cleared by then, but I know like if you do the 14th.
No, I'm going to do the 14th, which is next available date. And I'm doing that over the objection of the plaintiff because I really could try to insist upon a judgment, but I'm trying to give you 2 young ladies a shot. So what I want to see is substantial payment because you say you have these things coming in.
Yes.
I want to see payments. Otherwise, I'm going to just issue a judgment on that date. I'm not going to be hearing anything else.
Okay.
Understood?
Understood.
And then I realize there may be a little balance left over that needs to be paid, but there's going to have to be clarification on how that's going to get done.
Okay.
Clear?
We're very clear.
Judge says the apartment is unlivable, then makes a heartbreaking decision. What began as a routine eviction hearing quickly became one of the most emotional moments in the courtroom. A property manager described an apartment in such terrible condition that even walking through it was difficult. According to the landlord, garbage covered the home, debris had been swept into the basement, and the living conditions were so severe that they questioned how anyone, especially children, could continue living there. The judge called the conditions deplorable and said that description was actually an understatement. When the tenant was given a chance to respond, she admitted the apartment wasn't in order. She insisted she had been trying to clean, explaining that some of what appeared in the photos was food rather than what people believed it was. She told the court she simply needed more cleaning supplies and more time to finish the job. But the judge reminded her this wasn't the first warning. Weeks earlier, she had promised the court she would clean the apartment. At the next hearing, she made the same promise again. Yet when the judge asked whether he would still find the apartment unfit for people to live in if he walked in that day, she quietly admitted, yeah. That admission changed everything. The judge paused before delivering his decision. He said he loved his job, but sometimes he hated the decisions he had to make. Looking directly at the mother, he explained there was simply no way she and her children could safely remain in the apartment. He acknowledged that he had already given her extra time because he wanted to believe she could fix the situation, but the evidence showed she hadn't been able to do it. The mother pleaded for one more chance. She explained she was unemployed, had nowhere else to go, and was trying to keep a roof over her children's heads. The thought of losing the home was overwhelming. The judge listened carefully, but he also had to consider the children's safety. After hearing everything, he ruled that there was no factual dispute left for the court to decide. He granted the landlord possession of the property, but extended the move-out deadline, giving the family until August 7 to leave, and urging the mother to begin making alternative living arrangements immediately. Before ending the hearing, the judge made it clear this wasn't a decision he enjoyed making. He told her he truly hated having to order the eviction, but believed the living conditions left the court with no